Hello, my name is Mark Mitchell, and I'm just doing a little assignment here for a graduate class at Tarleton State University. And hello, Dr. Banker. Well, I'm going to go ahead and talk through some of this. It's kind of a video, but it's also a flip chart, kind of like a PowerPoint here. So let me see if I can get me down here a little bit. So, first question that came to my mind: was due process followed in this case? And the law, the book brings this up a bit. The education is protected, can't be taken away without due process of some sort, right? And there's a few things, of course, that goes into detail about the different things involved in that. Expulsion, that one has to be a formal meeting with prior notice, with the right to be heard from the person who it's about, witnesses, evidence. All those things are supposed to happen if you're going to expel a student and remove them from a school, which is what this case did. So I'm going to share thoughts and then questions throughout here. The law grants authority to administrators. I did think that was an interesting thing, and it makes some sense. I think it's admirable of the law to do that. And it's funny when they do this in the law. It's kind of the same thing as in an ARD meeting. They don't say what the vote has to be, right? They say these members should be on it, and the committee makes the decisions, but they don't say specifics. Same thing here is they know that incidents are unique, right? That's why we have judges and officers and hearing officers and things like that. But they give administrators some leeway there, and I think that's very wise. I think it's very wise. So that's a really cool thing in the law that especially with students with disabilities, they can take some things into account there. Although the law also clearly states that they should follow the discipline procedures for everybody. Should also be for everybody, right? It's just that, we'll get there. So because the student had a disability, and that was Down syndrome, there are greater protections and things that have to be followed for a placement like that. These protections exist to eliminate the discrimination. I know you already know this. You're seeing, make sure I know this, but yeah, we don't want someone to be kicked out of school because of their disability. Okay, and if someone who was, to take an extreme example, someone who was blind, kicked over a can of paint that killed the school cat mascot or something, you don't want to kick out that person for killing the mascot. Like a little cat or something. That's an extreme example, but you wouldn't want to do that because that wouldn't really be fair, right? So it was a disability-related thing. Question here: was the IEP followed? And I know some of these may relate to the case, may not, but they're all questions that should be asked. If the IEP has, a BIP in place, a behavior intervention program or plan, then obviously that would need to be looked at. If it's not followed, you may have some big problems there. And parents can sue if you did not follow the IEP. So if someone gets into some trouble and you didn't do that, it can be problematic. The IEP should be followed, thus allowing for a free and appropriate public education. Now, so when this happened, did a functional behavioral assessment take place in response to this behavior? My reading of the textbook, within 10 days, one of those need to be performed. And it also, as far as I could tell, it specifically mentioned weapon and drug offenses, that one of those would need to be performed for an incident like that. So was that performed? The paragraph didn't say. So that is a good question, something that would need to happen. Let's see. I'm trying not to take too long. I don't want to waste anyone's time here. Waste your time, Dr. Banker. Let's see. Did the school follow the change of placement legal process? This is the big thing. Okay. The change of placement was removal, was expulsion, which is indefinite, which is permanent. Okay. When you go through that, there is as I've learned from reading the chapter, reading a little bit of rights law and things, you have a procedure to follow. You have things that you have to follow to make that happen. And there is a stay put provision there. I did think it was interesting, and it makes a lot of sense in the law, that when you have a weapons related incident or a illegal drug related incident, that a student be removed from the campus or temporarily for a time for just the safety of the students. In that dangerousness clause that goes back to, I think it's Honig versus Doe. Fascinating stuff, and it makes sense. You want to make sure kids are protected. So if I'm a parent, and if I have a school that a kid came to school with a knife and stabbed somebody else, right? I would not think it would be prudent to put that student back in that campus the next day. Okay, right? That makes sense, right? And so I can see that. In this case, I could even see a temporary, that would make some sense. There was cocaine found in his possession, and the circumstances should be investigated and looked at, absolutely. But I could understand some of the response to that. Now, I think I got ahead of myself here. If the student is considered dangerous, there are those emergency things that could take place. The temporary restraining order. Okay, if a student's considered dangerous, you can go through a legal process to present evidence before a judge or in a courtroom and get the approval to expel a student on a legal basis. Okay. But again, that's something that has to be done, and I wonder if that happened in their case. I know the student was arrested, so I'm sure at some point he went before a judge. And I put a little asterisk down here for the 45-day removal. Did he knowingly possess the illegal drugs? And I saw that the textbook said knowingly. Did the student know what was in the bag? If that security guard indeed said that he watched this person give it to this person, and then that person took it over and was about to give it to this person, did he see the student open the bag and look inside and see the cocaine? It didn't sound like it. It sounds like he convinced him to take it over there. So did he knowingly do that? So for a 45-day removal, you would, I'm not sure that even qualifies, but under the dangerousness clause, you could probably do a 45-day thing without too much trouble. But the expulsion is a whole other matter, because that's an education you're talking about, a permanent change of placement there. This is a huge question. I'm sure every student brings this up. The manifestation determination. I mentioned nothing about that. So, we're just left to wonder, were these procedural safeguards, in play here? Obviously the parents did have to use some of the procedural safeguards because they sued, right? And won, and he got back into school. But was there a manifestation determination meeting? I would think in this case it would be imperative. I don't think you could get by and conclude that without doing a manifestation determination. And I didn't really know what one. I've been a special educator for 6 years now. I've been in education for 11. And it's only been in the past 3-4 years that I've learned about a manifestation determination. And I've never actually, I think I've been in one meeting. And so the question, of course, is the incident, is the issue related to the disability or not? I was in one last year and it was, the offense was big enough, it was inappropriate contact, inappropriate touching other students. And they had the meeting, manifestation determination, and it was determined, no, this student does have control of those things and chose some bad choices. So, and sure enough, he would be disciplined, and it was made very clear to him. I made sure I was very clear with him that he will be disciplined just like anybody else if he does that again, and even for the ones he did, So, but we had to go through that, and that was a good thing to do. And I've heard of ones that go on that, of course, that go the other way, and it was determined that it is related. I've heard of those, never been in one yet. So, another thought about law enforcement. I didn't see a big problem with this. Okay, let me take that back. The wording of the paragraph I read, it's very unfortunate. I can't blame the school too much for calling law enforcement. There's cocaine on campus. Okay, I mean, you gotta do law enforcement, but to have them arrest that student, a student with clear disabilities, with documented disabilities, it seems a little bit extreme. But that's one of those things where it's a case by case basis, and maybe that's what they felt they needed to do. Obviously, we're studying law in a special, focused realm. I wonder about law beyond that. I really don't know a whole lot about the arrest and charges for that, right? I will say that I went ahead and looked up about, because it fascinated me, Down syndrome. How susceptible are people with Down syndrome to being taken advantage of? And I think I didn't find a whole lot online about this. Maybe it's just kind of they don't want to talk about it. I did see a news report from this past summer. A predator, but he's a guy that did apparently violate a law that convinced a Down syndrome female to send nude photos. And he was, now the female is 20 years old, but she had Down syndrome, and he convinced her under the guise of, I want to teach you something. Well, he was arrested, and I believe he was given 6 days in jail, and community service and probation, and a few, had to undergo a mental health evaluation. I'll send the link to that. It was just a brief article, but clearly, even in that case, I think the charge for that man was immoral use of, using a computer for immoral purposes. So they found some law to get him, 6 days in a county jail. But that's taking advantage of somebody. So I think most people, and I bet you that the reason, two reasons. Number one is that you have a Down syndrome person being taken advantage of. When you have a lot of documentation about that diagnosis, a lot of judges are going to take that into account, I would think. And number two, you have procedural safeguards in this whole process, manifestation determination, all these other things, that if they really didn't make a good faith, put a foot forward to actually, see the whole picture and really figure out if it's related to the disability, or if that student did indeed intend to distribute cocaine. I mean, that's a possibility. But that would need to go through a lot of hoops, I would think, in order to expel a student with disabilities. So hopefully this kind of showed a little bit of what I've learned here. Very interesting stuff. I think next semester I'm taking a behavior class, and hopefully I'll learn even more for this stuff. But overall, I admire the law. The more I learn about this, I admire the law as protecting the educational opportunity for everybody, and making sure that disabilities don't get discriminated against, or we try to. That's our ideal, right? It's our ideal. Anyway, thank you very much, Dr. Banker. If this isn't sufficient, I can do more. But I really enjoyed reading the chapter, and I will I will attach the what are they called? The reference page, including the reference to the article and things like that. Thank you very much.